Court is now open. You may be seated.
Good morning, Ms. Maron. Mr. Berman, good morning.
Thank you. Good morning, Your Honor, Madam Chief Justice and Associate Justices. May it please the Court. The facts of this case I shall limn very quickly. In 1966, Helen Zabrowski, who had lived in California by then for 26 years, opened an account in her own name at the Aerospace Credit Union. Sometime well after that, she added the name of her husband, Ralph Zabrowski, with right of survivorship. In 1994, while Helen is still living in California, Ralph died. She asked her nephew, Andrew McLeod, to come and assist her with the funeral arrangements and be with her at this very difficult time, and he flies out from Massachusetts, where he lives. While he is there, she gives him a signature card on this account, and he signs it for her, and some 7 weeks later, she goes to the bank and opens the account, puts his name on the account, again with right of survivorship.
Mr. Berman, the facts are interesting, but let me ask you this. Does California have a statutory provision governing choice of law with respect to the disposition of jointly held bank accounts?
No, Your Honor, not as far as I know.
So under traditional conflict of laws jurisprudence, whose law would we apply?
You would apply the law of California.
Why?
Because California has a greater interest.
What's California's interest?
California wants to know, with respect to its own accounts and the domiciliaries, and she is a California domiciliary when she does that.
But she's not a California domiciliary at the time of her death.
No,
correct?
she's not. But the point is that California doesn't know where she's going to move, and she doesn't know, presumably at that time, that she's going to move. She is a California domiciliary, and California has an interest in having...
Do you have to go that far?
No, I don't.
Isn't this a California bank account?
Sir, I don't have to go that far, Your Honor.
I mean,
even if she were a Massachusetts domiciliary who went to California.
It's a California bank account.
That's right. I agree.
Don't the cases say the situs of the account is the law you apply?
Yes, and it isn't as if this is a case of first impression in Massachusetts, but it certainly isn't a case of first impression, and this Court already has recognized that on its own motion in the Fiorio case.
Well, the Fiorio case was different because Florida had a conflict of interest, conflict of laws statute.
Pardon me?
Florida was Florida, correct?
Yes.
And that state had a conflict of laws statutory provision. It's a statutory provision that is very, very widely known, and some states choose to have it and other states choose not to have it. And there are clearly competing interests here, correct?
That's true, but not one of these cases that I have cited in my brief, and there are numerous cases, has ever been decided under a conflict of law provision in the state depository state.
I would think it would be simpler to look at it as she was in California, set the bank account up in California, and therefore would, at the time she set it up, would have expected the California law would apply, and in doing it, she accepted whatever the benefits or burdens of California law were with regard to that account. And then she never closed the account or moved it when she moved out of state. She left it there subject to California law.
And you might even go further because she's fully aware of the account when she moves. She tells them to start sending statements to Massachusetts, and we can get that from Exhibit 5, which is in the appendix. So she's very well aware of the account.
Does the record show that there was any activity on the account after she moved here, or was it simply sort of left on deposit out there?
The record is silent on that subject, and I do not know the answer to the question.
If we find or hold the California law applies, what are the consequences? Do we dismiss this action and say to the plaintiffs, go start an ancillary proceeding in California?
No.
No? Well, the account is, the asset is still out there, is it not?
No,
And
the asset was taken out by the defendant, McLeod. He withdrew the money from the
Oh,
account,
okay.
as he had a legal right to do, and
It's now here. It's now in
Massachusetts.
Massachusetts.
Pardon me?
Okay.
It's now in Massachusetts.
That's correct.
Okay.
Well,
So,
but there
And
still
what
is
do
a
we- and what do
question.
we do with the fact that, again, in the absence of a conflict of laws, what do we do with the fact that there appears to be, at least as I understand it from the record, indications from her that she was striking out her nephew, Mr. McLeod's name from the bank statements and so on?
I don't think we can do anything with it, assuming that, and the judge, this is a very, very fishy circumstance, Your Honor, because she's been getting monthly statements, presumably, and we have 2 of those statements with his name stricken out on it.
Mr. Berman, that may be the case, but here's my concern. Sometimes people open joint bank accounts and don't know what the law of that particular jurisdiction provides. They don't. I mean, they're not lawyers, so they don't know what the law provides. They happen to be in Tennessee, they happen to be in Maine, they happen to be someplace or another, and they open a bank account because that's where the bank account is, and then they move someplace else, and they leave the bank account there because it suits their purposes, or they don't want to move their bank accounts every single time. So they may not know what the law is.
You know, Your Honor, people often don't know what the law
Correct.
is, and I agree with you on that. There's only one thing, for many reasons, and this has been a societal decision made long ago. We presume knowledge of the law. We presume it even in circumstances where the stakes are very, very high, as in the criminal law, and we have to presume it.
Well, yes and no. I mean, sometimes there's a very strong competing interest here, which says you look to what the testamental. This is her money. This is not the state moving against somebody. This is her money.
No, we presume it in civil cases as well, Your Honor, with respect to the law of contracts and the law of torts. If you go into another state and drive your automobile and you have an accident in terms where under Massachusetts law perhaps you would be totally in the right, but under the law of that state you are totally in the wrong, the law of that state will govern it.
Well, I gather here, excuse me, the actual bank account itself had some statement on it that with right of survivorship.
That's correct.
This was not some feature that was buried in the law of California of which she would be ignorant. It was right on the terms of the documents opening the account or setting up the account when she did.
That's absolutely correct, and, you know,
but what's,
But where is the question?
That may be so in this case, but if we say for all cases, in the absence of a conflict of laws statute, that wherever the bank account is, no matter what the testamentary intent was, the domestic law of a foreign state, foreign in the United States or elsewhere, governs no matter what the testamentary intent was. So that if she had written a will that says, I am aware that my nephew is alive, I've had a falling out with my nephew, and I intend to make it crystal clear that I do not want him to inherit at all from any source whatsoever, not this case, but a hypothetical case, people like, relatives out of the wind, or a brother, or a son, or a daughter, and you say, well, too bad.
yes, that's exactly what I do say, Your Honor. The law of California would apply. If she wanted to change this, she had a perfectly appropriate way of changing it under California law.
But the question of survivorship can, even under the law of California, can be litigated, I take it, if there's a showing by clear and convincing evidence that the intent was not that the person succeed to the interest in the bank account. Where is that going to be litigated if you prevail? In California or in the probate proceedings here?
It has been litigated, Your Honor. It has already been litigated.
But where should it be litigated?
I would think that, frankly, it should be litigated where the estate is, the administrators are, which is Massachusetts, and where the defendant is, which is Massachusetts.
Okay, so it will be considered as Massachusetts property, at least for purposes of probate. But you're saying we should apply the law of California as to survivorship.
No, it isn't because the property is in Massachusetts, and I don't go that far, and I don't think it should be considered Massachusetts
The
property.
decedent.
It's a question of where do you find the parties?
Yeah.
And you find both parties here. And we very frequently have litigation in which two parties who are both in Massachusetts litigated in Massachusetts over property located in another state or even another country.
And this is about whether this property should or should
Right.
not be in the estate.
In
That's right.
Massachusetts.
And so that
Exactly.
can be, the
Litigated.
question of what is and isn't in the estate can be litigated where the estate's being administered.
Now, what follows
Precisely.
from California law here, in your view? It was properly litigated in Massachusetts. The standard was supposed to have been clear and convincing. Is it that they didn't meet their burden of proof, and therefore that's the end of that?
Your Honor, that's exactly what I would say, and I was going
Was the
to-
judge operating on clear and convincing, or was she operating on preponderance?
Oh, she was operating under preponderance. She obviously refused to apply California law.
If it's clear and convincing, what do you do with the hearsay statement by, I think it was Miss Stanley or somebody by that name, that says she told me she put them on the account for convenience purposes, or words to that effect?
All right, that's you disregard it is the short answer, and this is where I was going to open a law almost 12 minutes ago. I was going to read.
Why do
from-
you disregard it?
I
It's
was going to
clearly
read from the
relevant on her.
defendant's brief, where he says, the obvious conclusion to be drawn from the facts and circumstances surrounding the account, its original creation as a single account, and then the subsequent additions of Helen's husband, and after his decease, the addition of Andrew, is that the joint aspect of the account was for convenience only, paren, emergency as testified by Stanley, close paren, or for some other purpose, such as to avoid probate in a foreign state of any asset held by Helen. And I said, what convenience are we talking about? She opens an account in California. She lives in California. She puts Andrew's name on it in California.
And he lives in
Andrew's
Boston.
3,000 miles away. He's in Massachusetts. Does she think if she becomes frail and needs $100 every Saturday, that Andrew is going to fly out every Saturday and take $100 out of the
In
account?
contemporary purposes, you can have somebody who knows of her circumstances, apparently assisted her when her husband passed away. He's a younger person. She thinks that she can lift up the telephone if she can't get down to the bank and say, please pay these bills, wire these funds. The suggestion that the only way that you can engage in economic activity is by in-person presence is absurd.
Well, she, as a matter of fact, he can't do this. She has the right during her lifetime, and you would want to look at Chapter 5303 of the California Probate Code on page 34 of my brief. She has the right at any time to withdraw money, and presumably she can do this by mail, she can do this by wire. She doesn't need Andrew for that. There's no this is like saying I bought a fire extinguisher in case there's an emergency in my house, and somebody says, where did you put it? Well, I put it in a storage facility 10 miles from here. It doesn't make any sense.
What is California's law on intent here?
California does not have a specific law on intent, but it says, with respect to an account that you open in joint names, that it's presumed that you intended the person to have the money in that account after your death, unless there's clear and convincing evidence to the contrary.
And I take it here you actually have two hearsay statements that are inconsistent with each other.
Yes, you do.
One of the hearsay statements is testified to by an interested party about, she told me she set it up for convenience. She didn't want Andrew to have it. And the other was testified to by someone that Andrew didn't know, who was her housekeeper.
That's
that in
correct.
fact, she intended to give something to Andrew.
I have something for Andrew.
Yeah.
So I really suggest that the story here of convenience or probate in a foreign state, which foreign state? Was California the foreign state? Massachusetts the foreign state? What could she possibly have been thinking? And I think you begin to realize the emptiness of the arguments to be made in favor of the plaintiff's case. I thank you for listening to me. I have finished 28 seconds early.
Thank you, Mr. Berman. We greatly appreciate that.
Vinny.
Mr. Barnes, good morning.
Good morning. May it please the court, Donald Barnes for the co-administrators of the estate. This case was...
Would you agree if we do opt for the California rule that this evidence doesn't make it on a clear and convincing standard?
I don't agree that you're talking about the evidence of Mr. Barboza, the conversations that he had with...
The intent
Well,
of
the whole
Helen.
thing on what the testator's, the woman's intent was. Do you get a new trial here? I mean, if the judge is operating on the wrong standard of proof, do you get a new trial?
Well, I don't... I believe that under any standard, this judge made the right decision here.
So you think it's clear and compelling if we get to that?
I certainly do.
Well, could I ask you, it seems to me, as I understand it, the California statute says that you have to overcome this clear and convincing hurdle, even if the only thing about the account is that it's been designated as a joint account and is otherwise silent on the
Right.
issue of survivorship. That even for that, you've got to come up with clear and convincing evidence. But here we have a count that from its inception was designated joint account with right of survivorship. So you now have to come up with clear, it seems to me, with clear and convincing evidence to overcome an express term on the account, not just an implicit, where the person opening the account might not know that joint account means survivorship, but where it says on its face it entails survivorship. Sounds to me you've got to come up with something really powerful to overcome that.
Well, we certainly have, in this case, the decedent controlled the account at all times, wrote all the checks, made all the deposits.
I must say, to me, that doesn't say one thing or another about whether or not she intends survivorship rights.
Well, here in Massachusetts, we have the same analysis as well as does California, that the California statutory scheme leaves room for probate administrator to come forward and say, no, the intention here was that this wasn't a present gift at the time it was made. It was just for convenience as well in California.
Can I ask you, how could it be for her convenience if she's later giving him inaccurate and apparently deliberately false information about what's in the account, leading him to believe that the account is completely depleted? How is that for her? How is he then supposed to use it for her convenience?
Well, the idea is that when people from time immemorial have placed family members on accounts so that they can get access to the accounts in times of emergency or whatever, and in this situation, her siblings, her brother, 92 now, another sister, 96, the defendant appellant's mother, who would be an intestate heir in this case, in her mid-80s. He really was the only person in the family, or one of them anyway, who could, if necessary, go out to California, secure the funds, or do whatever had to be done. I mean, people perceive
But
this
Mr. Barnes,
all
I
the
would
time.
ask you the same question I asked Mr. Berman. It seems to me that to suggest that you have to be physically present in this day and age to have control over a bank account is palpably not reasonable.
It's not reasonable, Chief Justice, but it's perceived all the time by people that they may need someone to physically go to the bank and take out
I
the money.
don't see, is there evidence of that in the record?
Evidence that she considered that?
No, the people perceive all the time that they have to go somewhere to close a bank account.
Well, I think in our case law, in many of the decisions of this court, there's a recognition that people want to control their assets.
Of course they
hold
want to
on
control
them.
their assets.
Even though they may begin accounts with right of survivorship, it wasn't their intention to do anything other than to keep dominion over those accounts.
During her lifetime, was her nephew, was it possible for her nephew to write a check and draw funds on the account?
It was always possible, in accordance with the contract with the bank, he could borrow against, so forth
Okay,
and so on.
so-
But
so that
he
her
didn't
te-
have access to any of the tools to do that, and did not do it.
Well, he didn't do it, but her telling him that the account was empty might have been so that he didn't attempt to gain. I mean, he could have written to obtain checks, or if he had wanted to. There's no suggestion here that this nephew attempted to improperly gain access to these funds. I'm not suggesting that. I'm simply trying to understand why she might have misled him as to what was in the bank account.
Well, I think taking all of the circumstances that the trial judge had the opportunity to consider from a conversation with Stanley, with the use of the account over the years, with the redactions on the account statements and the IRS forms and so forth, that she definitely was telling this fellow that you don't have access to
Maybe she
these
just
monies.
didn't want him to be responsible for any of the taxes.
Well, that may be, but the judge, I think, properly inferred that those redactions were to indicate that he was not involved in that account in any way, that he was not to inherit the monies in that account if she should pass away.
Mr. Barnes, in response to Justice Graney's question, you said that even if we apply California law, which clearly requires a showing of clear and convincing evidence that the testator intended something other than the right of survivorship, what's the strongest clear and convincing evidence?
The strongest is, the domicile here in Massachusetts of Helen Zaborowski. Second, the contemporary testimony given by her brother, a trusted brother, a close family member, when she made the account, as he testified, within a month or two of her husband's passing and the placement of the nephew on the account, he told her that it wasn't a gift, that it was for convenience or for an emergency only. The appellant's own testimony at trial, that when he inquired about the account, she told him that there was no account, or words to that effect. It wasn't available to him, and the account was closed.
You also got the, I think it's been referred to, don't you have the scratching out on the documents of his
The
name?
redactions
His
are...
name. And didn't they also find a purported will in
They did.
which he wasn't mentioned? I don't know which way that cuts.
Well, he was mentioned on there, but if you total up all of the figures, it
Doesn't add up?
would obviously include the funds that were in the aerospace account in California.
Well, that
I don't understand that answer.
Yeah.
would be an indication that she considered it her money, wouldn't it?
Yes,
Not his.
yes.
The draft will was in evidence?
It's the last exhibit in the
Appendix?
appendix.
And just, what provision did it make for the defendant, the draft will?
That he, aligned with his name is the figure of $100,000,
And how much was in the account?
142 something.
Was the will drafted before or after the creation of the right of survivorship?
Well, it wasn't a will. It was apparently done fairly, I think it's dated March 2003. She died in June of 2000.
So it was long after the account.
There's
Long
a,
after.
there's a specific item in the will for him?
Well, it's not a will, it's just a list of figures. I would say a putative will. She began
But
to...
she's got his name in there with 100,000?
That's right, as well as her brother with 100,000 and others with 25,
Doesn't that cut
50.
against you?
Excuse me?
Doesn't that cut against you, your position?
Well, it cuts
Ambiguous.
against the figure of 140,000 versus 100,000.
Yeah, but
that she
otherwise
intended to
we're going-
leave him something.
Something
not,
significant, something equal to her siblings, whereas under what you're arguing for, he gets nothing.
Well, there was a residence and so forth, and his mother is listed on that putative will as well. But you're right that it does indicate that she was going to, or intended ultimately, if she did complete the will, favor him significantly. Nonetheless, she was favoring others in the family just as significantly, and never made the will.
It's pretty hard to
And-
say when you put the whole thing together that you've got clear and convincing here, from
Well,
your point of
again,
view.
I would argue that fair preponderance of the evidence and clear and convincing, or as the trial judge recites in her conclusions of law, that the attendant facts and circumstances were viewed and persuaded her that the funds should stay in the estate.
If we decide-
Where does she say that? I'm sorry. I read her opinion, and she makes all kinds of findings of fact, literally finds every fact apparently that was testified to, which go both ways, and her conclusions of law are just general conclusions. Where is this finding?
In the conclusions of law, she does cite the recitation from Massachusetts cases that refer to the...
She says, "It is always possible for the decedent's estate to show by the attendant facts and circumstances that the decedent did not intend to make a present completed gift of a joint interest." That's what she says. Well, I guess that's the law, of course. But where does that take us?
Well, her review of the attendant facts and circumstances in this case led her to conclude that the funds belong to the estate.
But doesn't that depend, Mr. Barnes, on which standard one is attempting to meet? In other words, if the California statute didn't have what the required standard of proof was to overcome a presumption, then presumably she would have looked to California law under the defendant's theory to figure out what California law would look to overcome.
Well, two comments on that, Chief Justice. One is that the funds were transferred from California to Massachusetts. There's no ancillary administration, no need to go to California and, in a court there, determine where these funds should go. They were transferred to Massachusetts. The administrators have a duty under Mass law to marshal the assets and determine which assets belong to the estate, and
You mean they were
the law of the
transferred- they were-
domicile should apply at that point, and our standards should apply.
The assets were transferred by the nephew to Massachusetts.
Yes.
I have a loose end in my mind about that, and the answer may be very easy. But if the nephew had not been from Massachusetts, had been from Connecticut, and transferred the assets to Connecticut, you would have to take an ancillary administration out in Connecticut, wouldn't you?
More than likely.
All right.
If we decide California law applies and it's clear and convincing, maybe I've asked you this before, but is it your position you get a new trial because the judge was operating under the wrong standard of proof?
At least, Judge.
Do you have any other proof? But you don't have any other proof, do you? That you withheld thinking it was a lower standard of proof?
Nothing was withheld at the trial.
You gave it your best shot.
Absolutely. And the evidence before the court, in the probate court, I believe satisfies a clear and convincing standard as well.
What about the fact that she told him that the account was closed when he asked for some money? Doesn't that help your case?
It certainly does. And his characterization to others later that when she told me that she was lying to me is something that the trial judge can take into account when she weighs the credibility of him as a witness and his other testimony concerning the California situation and his favored status and so forth. And so
Well, I mean, that's remarkable because he brought this to the attention of the estate, this
That's
account.
correct.
He brought all of these facts to the attention of the estate. He didn't sort of sneak off in the night, take the money, and run.
How long after the account was set up did she have this discussion with him where she told him there were no funds in the account was closed? How much time had elapsed?
Probably 6-7 years, according to the testimony. But in answer to your question, Justice Cordy, there's just a situation here where you put all of it together, as the trial judge did, and made 40 subsidiary findings. Yes, some of them summarize the evidence on both sides. But
It seems like she found literally every fact that was testified to. And that just, I don't know what we do with that. I mean, she doesn't say, at least I don't see it in her ruling, that she says, and I find by a preponderance of the evidence or clear and convincing that the intended circumstances are that there was no gift intended. She doesn't say that in her ruling. Now, maybe that's said in the judgment, or maybe that's...
Well, the judgment just plainly says that she finds in favor of the estate and
But there's no question that
orders the defendant to turn the funds over forthwith.
But there's no question that she's applying Massachusetts law, correct?
Right.
I believe there's no question
And
because of the
Massachusetts-
recitation of all of that Massachusetts law.
And Massachusetts law does not have a clear and convincing standard, correct?
I believe that's correct, but fair preponderance of the evidence, clear and convincing. I note that in the Moussaoui trial that was just concluded, the
Criminal trials are
standard
not...
there was fair and preponderance in a matter so serious as death.
The question is not what's the appropriate standard, there's clearly a difference in the standard, and if you apply California law, it has to be clear and convincing.
Thank you, Judge.
Thank you, Mr. Barnes.